As you are listening to our podcast, please remember we are not giving legal advice. This is for informational purposes only. If you need an attorney to help you, please reach out to an attorney within your jurisdiction. May it please the court. My name is Rwan Saffarini Hardesty, and together with my co-counsel Jason Larman, we represent The Appeal of It, a podcast designed to distill Texas Supreme Court opinions, Texas Court of Appeals opinions, and other Texas law to make it all more appealing. Hi, my name is Rwan Saffarini Hardesty, and I'm one of the co-hosts of The Appeal of It, a podcast designed to distill Texas Supreme Court opinions, Texas Court of Appeals opinions, and Texas law to make it more appealing. Now, the first case that I wanted to talk about is In Re C.J.C. Imagine, if you will, that you have a child with someone and you're no longer together. And you have some orders that put you as joint managing conservators, which basically means that you both have all of these rights and duties in Texas that allows you to raise your child, go to all of their events, figure out what school records look like, go look at their medical records, all of the rights and duties that a parent with a child would have. And your ex-partner marries somebody else, and now your child has a step-parent. That step-parent has been with that kid about 6 months or more, and your ex-partner decides that they're going to file a modification suit because something has changed in the circumstances, either with you or with your ex-partner, or the fact that they got married, or something is just not going right in that situation. During the pendency of this modification, your ex-partner dies. The child's other parent dies. So what happens in this situation?
After your ex passed away, the grandparents wanted to protect whatever rights they had to access and help raise the child. So in Texas, the mechanism for that is that they file what's called an intervention, which is basically them intruding into the proceedings in order to assert the rights that they may have in the course of the otherwise, fight between the two parents.
Right. And not only that, in this specific instance, the step-parent, the stepfather in this actual case, also filed an intervention because he felt that he had rights to the child. And during the prior period of time, while the other parent was still alive, this step-parent had, control of the child, had helped raise the child, and was basically asserting any parental rights that he could have as the step-parent.
All right, so just to be clear, we have one parent on one side, and then the parent on the other side has passed away.
Yes.
And their new spouse has intervened, and their parents have intervened.
Correct.
So on sort of mom's side, dad's side, one side has just the actual biological parent, and the other side actually has grandparents and step-parent, but no actual parent because they've passed away. Is that right?
Yes.
Okay.
So in this specific instance, in Re C.J.C., it was biological father that was still alive. Biological mother had died. Step-parent, so stepfather, had intervened, and what we would call maternal grandparents had intervened. So those are the parties. What ends up happening is the grandparents get kicked out for standing. The court decided that they weren't allowed to have any rights to the child other than what would be considered grandparents' rights. And that really isn't what this case is about. This case is more about whether the stepfather was allowed to have all of the rights and duties that a biological parent would have. So first we have to talk about exactly what the trial court ruled. And this case actually comes out of the Denton County 16th Court of the 16th District Court, and the judge there in the actual trial court, and the preliminary stage. So we don't even have a trial yet in this case. Most people think that cases go from filing to trial. But in family law cases, we actually have something called temporary orders, which help us to kind of put a status quo with whatever is happening in a familial relationship. So the court ends up issuing temporary orders, says that the step-parent has standing because he has actual care, custody, and control of the child, and grants him a possession and access schedule over the child, even though the biological father said, I don't want him to be involved. So what they did was they gave stepdad, whose name coincidentally is Jason, which is, at least that's who they named him as here in this case, they gave him the ability and the unrestricted duty to care, control, protect, and give reasonable discipline of that child. They also gave him a possession schedule where he was allowed 6 hours every second and fourth Saturday for 4 months, and then the following 3 months after that, he was allowed to have overnights. Now, the court did say that all of these visitations had to occur with the grandparents there. So on top of that, the court told the parties that father and stepfather had to discuss anything about the child through electronic communication. So with the trial court's order at this temporary order stage, the biological father was not pleased with having to co-parent with the stepfather. And because family law cases take a long time, what he ended up doing was taking this temporary order to a court of appeals through what we call a writ of mandamus. And what that does is it just takes a specific portion of the case to the court of appeals so that they can make a decision as to whether or not the judge made the correct decision. And ultimately, the Court of Appeals, which would be the first step when you're taking a writ of mandamus up, said, no, the trial court was correct in their ruling. Well, biological dad still didn't like that. And so the next thing that he was able to do was do another writ of mandamus, or basically a petition, for the Texas Supreme Court to look at whether the trial court and the Court of Appeals made the right decisions. And ultimately, if we want to go all the way to the end, the Texas Supreme Court said, no, everybody is wrong. But to get there, there's a lot of law that needs to be discussed and a lot of constitutional law that needs to be discussed. And what they really said was that the biological father has this presumption that he is a fit parent, and fit parents are presumed to do things in the best interest of their children. And therefore, they can choose who their children are allowed to be around and what they're allowed to do and how to discipline them without any interference from the state or any other state actors.
All right, now I'm going to push back a little on the word presumption. Basically what you're saying there is, in the absence of evidence to the contrary, we just assume that every parent is a fit parent. And then until we have reason to believe otherwise, that is the way we look at it. Is that accurate?
That is absolutely accurate.
Okay.
And so where that actually stems from is from the U.S. Supreme Court, which is, it actually comes from the U.S. Constitution, where parents have a fundamental right to raise their children in a manner that they seem fit, or that they deem fit. And then there was a case that was just decided by the U.S. Supreme Court named Troxel, which we are not going to get into, but it basically also says that there is a presumption to parents doing things in the best interest of their children when they are raising them. But here in Texas, even before the Troxel case came out, there was legislation and the Texas Constitution both had this presumption that basically said parents do things in the best interest of their children, and unless there's something that would cause significant impairment to those children based off of how the parents are raising them, then no state actor is allowed to come in and change it.
And that can be anything from the parent making choices that are clearly detrimental to the child to a parent suffering a disability that renders them no longer capable of caring for their kids. Is that accurate?
That is accurate, yes. Okay. So with this fundamental right, typically what happens in a child custody case or a divorce or a suit affecting the parent-child relationship, which are all basically custody cases, a parent would come into a court and say, I want some sort of court orders that tell me what rights and duties I have to a child. And when it's an original suit, so it's the very first divorce with that child being involved in it, or it's the very first suit affecting the parent-child relationship with that child being involved, it is absolutely presumed that a parent is considered a fit parent unless we find something else during the course of the trial. What wasn't clear was in modification suits, which is where we are in this case, where we've already had underlying orders and we're moving into a way to change the orders, whether that presumption applies to parents automatically. The biggest issue that came up in this case was that father and stepfather were arguing about whether the fit parent presumption applied in a suit that was secondary to the original suit where custody and the determination of possession and access was decided between biological father and biological mother. And what the father was saying was that no matter what, because he was determined to be a fit parent in the underlying and original lawsuit, that should continue to move forward through any subsequent change or any subsequent suit regarding his child and the child that was involved in this lawsuit. What the stepfather was saying was that the Texas legislature only placed language regarding the fit parent presumption in suits that were considered original suits, and they left that language completely out in what would be the modification suit. What the Texas Family Code's modification suit statute says is that a court may modify a court order if it's in the best interest of a child and the circumstances of the child or a conservator or other party affected by the order have materially and substantially changed. So because the language regarding the fit parent presumption wasn't included in that modification statute, the stepfather was saying there was no reason for there to be a presumption, and therefore anybody could bring a modification statute so long as they were affected by the original suit.
So to clarify, just for my understanding, and maybe this will help the people listening as well, Dad was saying the legislature made me a fit parent by law in step one, effectively.
Yes.
And since I was a fit parent at step one, in the absence of evidence to the contrary, I get to stay a fit parent. Again, in the absence of evidence to the contrary. But then stepdad took the opposite approach and essentially argued that even if he was a fit parent at stage one, we're now in stage two, and that presumption has expired. Is that accurate?
That's essentially what he was saying.
Okay.
Yes. What essentially ends up happening is the Texas Supreme Court looks at the trial testimony to see what was actually said by the parties during that case. And what they end up finding is that the stepfather and the grandparents never actually said that the father was an unfit parent. And so they hinged their opinion upon that fact and basically said that because he had already been considered a fit parent, that he does have that presumption. Said another way, the Texas Supreme Court said that if there is any best interest determination, which means what is in the best interest of any particular child in any particular suit, whether it is an original suit or a subsequent modification suit, that a court needs to weigh whether a fit parent's rights are appropriate against the conservatorship and access of a non-parent. Essentially, there is a presumption that, again, a fit parent acts in their child's best interest, and a non-parent must always try to overcome that presumption if they're trying to gain access to that child.
All right. So if I had to just boil this down into like an elevator pitch in some way, essentially what they found is that in the absence of evidence to the contrary, a parent who's making choices in the best interests of their child has the ultimate right to decide who that child interacts with. And ordinarily, where it's two parents, the other parent would have an equal right to make those decisions. But because in this particular case, that parent was no longer available because of their death, there was no equal right to then be passed on to anyone else. And instead, in the absence of evidence to the contrary, the parent making choices in the best interests allows that parent to choose to include or to exclude anybody else in that child's life, even if that person would have been more active in their lives in the event that the other parent was still surviving. Is that accurate?
That's accurate.
Okay.
There are some specific instances where that wouldn't be accurate, and we'll discuss that in a little bit. But first, basically what we have to talk about is what makes a parent fit and what evidence would show that they were not fit ultimately.
Well, I guess really the question is what makes a parent unfit because of that presumption, right?
Right. So
because every parent's presumed to be fit in the absence of evidence to the contrary.
Correct.
Yes? Okay.
Yes. So in this case, there was a concurrence opinion, and let me have Jason explain what a concurrence opinion would mean.
All right. So a concurring opinion. So anytime you're in a court of appeals, you're going to have anywhere from 3 to potentially up to like 9 judges that will all essentially have a vote in the outcome. And what you typically will see, and this is where you see, like in Supreme Court cases, they'll have the 5-4 decision or the 6-3 decision. And that's whether those judges sign on to a particular side. But the reality is there may be portions of the sort of main opinion, sort of the trunk of the tree, that some judges may not completely agree with, even if they agree with the outcome. So you'd have a concurring opinion, which is a judge who agrees in whole or in part with the ultimate outcome, but has their own things that they want to say. And it might be completely separate from the majority opinion, or it might just partially align with the majority opinion with sort of their footnote to add to it. And then a dissenting opinion would be a judge who disagrees with the outcome and has their own piece that they feel is important to put in there. Does that make sense?
Yes. Oh. Okay, so there was a single justice who wrote a concurrence in this case, and what that justice ended up saying was the question that wasn't answered in Re C.J.C. was what was the proper evaluation of whether the fit parent presumption has been overcome by a non-parent in any particular case. So that's a very fact-intensive type of question that needs to be answered by trial courts and then court of appeals anytime that a non-parent is asking for visitation over a presumed fit parent's objection.
So I've used the phrase a few times now, in the absence of evidence to the contrary. Essentially what you're saying is that this judge was pointing out that the majority opinion, by the time the Supreme Court was done with it, didn't explain sort of what bundle of facts or what you'd have to bring to the table to overcome that presumption.
Correct.
Okay.
So this case was decided in 2020, and we are now 3 years out, and there have only been 71 citing cases to this matter.
Now, is that a lot in 3 years or not a lot in 3 years?
It is kind of average for 3 years because each time a case is cited, it can be cited for various propositions that are included in its opinion that's been written by the Supreme Court. So a lot of the citing references were just for the proposition that parents have this right, this fundamental right to parent their children how they deem fit. Not many of the cases have really discussed what it means to overcome the fit parent presumption.
All right. So when it's been cited 71 times, the reality is a lot of those are just instances where they're just cherry picking a particular specific point within the case and not dealing with a similarly complex set of facts.
Correct. So before we get into those 71 cases, that concurring opinion from that justice also said that there was nothing in the code that showed how to overcome the presumption either, and that there were other state Supreme Courts that had given some guidance, but not enough to really get us to a point that we could truly overcome the presumption or let people know how to overcome the presumption. So we get into the last probably 6 months of this year. So from maybe February of this year until now August of 2023. And more courts are starting to take up this issue of what is enough to overcome the parental presumption in a modification case. So the most recent case, or one of the most recent cases, is from July 19th, 2023, and that's the date that the Court of Appeals issued an opinion. And in that specific case, it was a Department of Protective and Family Services case, which is our CPS program. And what they ended up saying was, if there are...
No, I'm going to stop you. You're saying they.
They,
when you
the
say
court.
they, do you mean the court, or do you mean the state CPS, Department of Family and Human Services, that you just referred to?
That's a good question. So it's actually the court ended up saying that based off of the facts in this specific case, and it was called In the Interest of RL, when a parent who may be considered a managing conservator is trying to manipulate a situation or is obstructing visitations with another parent or is causing some sort of mental manipulation of the children, that is enough to modify a situation from what it had been prior to what it should be now.
So that would go back to the material and substantial change
Yes.
component that we talked about earlier in modification. Is that right?
Correct.
Okay.
Okay. And so on top of that, we have another case that came out in July of this year, July 6th of 2023, and it's an unpublished opinion, which, do you want to discuss what unpublished versus published means?
No.
No? Just no?
No.
It's an unpublished opinion. And in that case, we have a grandparent intervening, very similar to In Re C.J.C. and Troxel, where they alleged that parents that had prior been considered fit parents were now engaged in a history or pattern of child neglect. At trial, the trial court entered a final order that did find the parents unfit, but then they appointed one of the parents as a managing conservator. The problem with that is when a parent is appointed a managing conservator, then they are presumed fit.
Now, what is a managing conservator in Texas?
So a managing conservator in Texas, so there are multiple ways to be a conservator. So in Texas, we have managing conservators, and then we have possessory conservators. And managing conservators have more rights and duties than possessory conservators. Essentially, they are the parents.
So break it down one step further, because conservator's not a word that comes up for a lot of people. What is a conservator?
Oh, gosh.
Is that just the label they put on a parent who's still actively managing their children?
Either a parent or another non-parent, such as the Department of Family Services or CPS. Or
So in just lay terms, it would be that line on the, the school form or the doctor's form that says parent or guardian.
Correct.
It's essentially that role.
Yes.
Yes? Okay.
Yes. So what the Court of Appeals in this case, these aren't cases that actually made it up to the Supreme Court. These are just Court of Appeals cases at this point. What they found is that at trial, the court was able to find testimony that the mother, in the interest of KLC, had been a current drug user and had untreated mental health disorders. She was not the parent that was named a joint managing conservator. She was the parent that was essentially named a possessory conservator. So she didn't have all of the rights and duties. I know it's a lot of conservators.
You know I'm going to do this to you. Why don't you just take a second and just break down sort of the different levels? Because essentially there's a hierarchy, right?
Yes.
Managing conservator would be sort of top of the food chain for the most part, right?
Correct.
And then who would be sort of secondary to that?
Secondary would be a possessory conservator.
Okay. So in terms of, I guess, which parent has the greater authority, managing conservator is sort of the top, and then what was the second one?
Possessory conservator.
Possessory conservator would be someone who has the right to possession of the child, but doesn't have the same decision-making responsibilities that a managing conservator does.
Absolutely.
Okay.
And sometimes even that right to possession of the child would be, they have rights to possession, but it would be under very specific circumstances, like it would be supervised, or it would just, they wouldn't actually have possession unless it was agreed upon or something.
And
specific.
that would come down to the details of the particular case, correct?
Right,
Okay.
yeah. So in this specific case, the trial testimony again was that the mother was a current drug user and had an untreated mental health disorder. And with regard to the father, the grandparent of the child testified that the father was immature and used a lot of profanity and threw temper tantrums. And then on at least one occasion had failed to check on the child when the child had screamed and allegedly had fallen down a set of stairs. The grandfather also testified against the father that said that the father lived in this rundown, dilapidated shack, but that he'd never been inside of it, and so he couldn't actually testify as to whether it was an appropriate place to live or not. At trial, the father then testified that the dilapidated shack that was referenced was actually his work and not his home, and that the child would cry anytime he would have to go to the grandparents' home. And he did acknowledge that mother should not have any access unless she demonstrated sobriety through some sort of drug testing or some other manner that they were comfortable with possession being had. Essentially, that Court of Appeals said that this evidence of...
Now, I don't think we were totally clear on this when we started talking about this case. Is this a case where the state is trying to intervene and take kids away from parents? Or is this a situation where parents are trying to have a court decide between them how their kids would be managed?
So this is a case where the grandparents intervened because they alleged that the parents were engaging in a history of neglect of that child.
Okay, so the parents didn't disagree with each other about things to get it kicked off.
Right.
The grandparents were concerned enough that the grandparents sort of inserted themselves into the lives of them to try and protect the grandkids.
Correct.
Okay.
So what ends up happening here is the court basically said the grandfather's testimony just wasn't enough. The father's testimony wasn't really enough. And none of that, without actual proof as to what the home looked like and what types of impairment there could have been to the child, were enough to prove that there was an issue with the father, specifically that he was an unfit parent. Basically, the grandparents didn't overcome the presumption, at least to the father.
Okay.
So they do cite to multiple other courts, and this is kind of the last case that I've seen that's dealt with this issue to this date, but I'm sure there will be many more as we go on into the future. But the San Antonio Court of Appeals, the 14th District Court of Appeals, which is Houston, the First Court of Appeals, which is also Houston, and in this case it was Corpus Christi Court of Appeals, they all basically have said that to overcome the fit parent presumption, a non-parent, grandparent, step-parent, a family member that would fit under the code, whomever, must prove at a minimum that the physical health or emotional well-being of a child would be significantly impaired if the non-parent was not granted custody, and that child would continue to be significantly impaired if access was continued to be denied, or if the denial of access continued. And then they all said that there must be evidence of a specific identifiable behavior or conduct that will probably result in that significant impairment. That's a whole lot of words, and nothing is defined. So we have to go into what all of these courts have decided, when they decide what is a specific and identifiable behavior, we have to see what the courts are saying is specific and identifiable. So luckily, the First Court of Appeals, which again is Houston, has stated that some identifiable behavior or conduct may include physical abuse of the child, severe neglect of the child, abandonment of the child, drug or alcohol abuse by the parents, and that's significant drug or alcohol abuse, immoral behavior on the parts of the parent. That also was not defined as to what would be.
Sounds like its own Pandora's box.
Yes. So we don't have a definition as to what immoral behavior is. And then the Amarillo Court of Appeals added a couple in May of 2023 that said aggressive, disrespectful, and or hostile behavior towards a family member would be considered an identifiable behavior. And threats to family members, failure to abide by court orders, and also taking children to places that are unsuitable for children would be considered specific and identifiable behaviors.
All right. Now, just to kind of clarify, when a court finds one of these things, does that mean they have to find that it's an unfit parent, or is there sort of a mix of a bunch of different factors, right? If you have, for example, if you have a parent who is otherwise doing a good job, who's disrespectful to a family member, does that mean that they are suddenly not entitled to the presumption of being a fit parent? Or does that just weigh into sort of a whole network of different factors in order to make that determination?
It has to be, it's more of a factor analysis. So everybody has a bad day. Everybody decides to do something that may not be in their best interest, in the best interest of their child every once in a while. But if it's a persistent type of behavior, so the best way to discuss that is drug or alcohol abuse. If you're consistently doing drugs in front of your children and they are exposed to your drug abuse and could potentially be exposed to secondhand smoke from, doing marijuana or other illegal substances, then that would be enough to get you there.
And ultimately, that's a consideration that attorneys and judges and everybody are sort of tasked with sort of finding common ground on when they can, and when they can't, then it ends up in cases like this where
right.
Everybody sort of puts everything they have out there and somebody has to make that balancing act work.
Right. And so what ultimately it comes down to is you take all of these things that are occurring, how pervasive they are in any particular situation, and then you have to also show that this would significantly impair the child in various ways. So, kind of that immoral behavior issue, right? What is immoral behavior? Someone can do something immoral and have immoral behavior that doesn't affect the child because the child isn't exposed to it. So, when you take that factor analysis into account, if you can't prove that there's some sort of significant impairment to the child, then you're also kind of poured out on that issue.
And by poured out, you just lose.
Right, you just lose.
Right. So essentially, you're saying there's got to be some connection between the parent who's doing any one of these things and the actual behavior. So a parent who's disrespectful to a family member only in private meetings and not around other family members or the children or whatever wouldn't carry the same weight or be as significant of a factor as the parent who maybe at a family function, goes into an expletive-laden tirade against,
Right.
the child's beloved grandmother or whatever.
And in front of the child.
Exactly.
Right. So what other courts have said is if there's a very close familial relationship between the child and a non-parent, whether that could potentially affect the emotional well-being of a child is considered as well. So there is a case that isn't post In Re C.J.C, but is prior to that, back in 2007, where the Corpus Christi Court of Appeals did say that if a child had previously resided with, say, a grandparent or a non-parent, and that non-parent or grandparent was essentially placed in the shoes of being a parent, being referred to as mom or dad, or doing all of the functions that a parent would be doing, that if you remove a child from that situation, that is in and of itself, well, that could potentially cause significant impairment in that child.
So, for example, if in that first case we talked about in Re C.J.C, where stepfather wanted possession and access of the child after the mother's death, if that had perhaps been, a 16-year-long relationship and child had primarily spent time at mother and stepdad's home and dad was a very minor actor, a very minor player in the child's life, essentially what you're saying is under that set of facts, that might be a situation where a court would say dad's decision to sort of disrupt the child's life and yank them out of the house they grew up in might in and of itself be a bad enough decision to make us question that original presumption.
Right. So it's basically whether we have a situation, it's basically a two-pronged issue. So first you have to have a fit parent, and then once you have a fit parent, whether taking another person out of the child's life would significantly impair that child to such an extent that it would be traumatic, then we can overcome the presumption and add rights to somebody that may not be a biological parent.
Essentially forcing the hand of the parent who isn't necessarily fit to allow that other positive influence in the child's life.
Right. And it could be a parent that is fit, but we're having this other issue where we've got a traumatic situation. So the courts have said that...
Well, then maybe I didn't follow you there, because what I heard is that decision to inflict that traumatic event on the child might be one of the specific identifiable conduct things that a parent could do that would potentially overcome the presumption of them being a fit parent.
Right. So we've got cases where parents have decided that a grandparent shouldn't be involved in a child's life, even though they had been involved prior. And in those cases, essentially what courts are looking at is whether removing that grandparent from a child's life would be so significantly impairing to a child that it would cause traumatic emotional situations.
Right.
Then that could be considered significant harm to the child, and the grandparent should have access. Now, grandparents specifically...
But, and this goes back to sort of explaining that In Re C.J.C case we started with, does that only occur in the event that they overcome the presumption of them being a fit parent?
So it is with specifically with grandparents. No, grandparents have a specific code provision that
allows. So the legislature has created a different door that grandparents can utilize. Okay.
Right. But when we're talking about non-parents, so the step parent, we would have to show that there was an unfit parent on the other side.
Okay.
Yeah.
Now being found to be an unfit parent doesn't mean you stop being a parent necessarily, right? So that in that situation, had they found that, father was an unfit parent and then granted stepfather rights as well, there wouldn't be, that's not an automatic event that takes all of dad's rights away. Just dad's right to make the decision about whether or not stepfather is also included in the kid's life.
Right. So it would be, he would potentially be placed in a possessory conservator position.
That's one of the options,
right,
sure.
Right. So it's all a balancing act when it comes to all of these cases. Every case is very fact specific, and unfortunately, because we're so new with this case, and it's the cases that are currently coming up through the Court of Appeals, there's really nothing that's very identifiable at this point.
We don't have a lot of examples of what counts and what doesn't, right? But essentially what we're saying, if I understand it correctly, is the legislature's created a particular door that grandparents can utilize. And there's another door that someone who's not a grandparent and not a biological parent could utilize. Mm-hmm. But in order to unlock that door, they have to prove that the parent they're sort of challenging for time or rights or whatever with is an unfit parent.
Correct.
And then once we sort of hone in on that, then there's a lot of, I guess, speculation and uncertainty as to what exactly would overcome that presumption, but there are a lot of possibilities.
Right.
Okay.
And so kind of a little practice point for any of the attorneys that are listening to this, you need to be specific. You can't just say that. One example that I found was there was a parent that was complaining that a child had a ton of tardies at school. We hear this all the time in family law cases. The other parent or the step parent or whomever is causing this child to have excessive tardies, and that's why the child ended up being held back a year. But testimony in instances like that to show that a parent is unfit just isn't enough, and the courts have been very clear in saying that. There needs to be testimony from as a trial attorney's perspective. You need to have the school come and testify that is the specific reason why the child was held back, and not because of something else such as, an aptitude issue, right, or needing special services or something to that effect.
So essentially it's cause and effect, right? It's one thing to point out that the parent is not punctual, but that's not enough to show that it's harming the child unless you bring that other piece in showing that it's harming the child.
Right.
Okay.
Yeah. And so, and another practice point that really needs to be discussed is there was a case where a modification was brought up, I believe, but it doesn't really matter. When a fit parent presumption does apply in either original suit or a modification suit, if you choose to go to a jury trial, that jury charge needs to have an instruction about the fit parent presumption. And this is just for attorneys. Attorneys will understand what we're talking about when we're talking about this. But ultimately, if you don't have that instruction, or at the very least object to the fact that the instruction is not included, you've completely waived your argument on the jury instruction.
Which essentially means that you've abandoned that presumption because the jury wasn't told to do it, and that's not a good thing for your client.
Right, not at all. Luckily, in the case that I did read about that specific issue, the Court of Appeals decided to go on a legal sufficiency standard on the fit parent presumption. And ultimately, they ended up saying that, like I was saying earlier, there must be specific evidence that shows that identifiable and specific behavior that would significantly impair the physical health or emotional well-being of a child if custody was not granted to a non-parent, and that it would continue if that denial continued. So that is In Re C.J.C. in some of its progeny cases, which are the cases that have come behind it or after it, and kind of an analysis as to how to try and overcome the parental presumption, the fit parent presumption. But we probably won't really know for at least another 5 to 10 years how all of these cases are going to kind of filter themselves out, and if we're ever going to actually have a good line of cases that show what types of situations would cause the presumption to be overcome.
Anything else?
That is it.
All right. Thank you for listening to The Appeal of It.
As you are listening to our podcast, please remember we are not giving legal advice. This is for informational purposes only. If you need an attorney to help you, please reach out to an attorney within your jurisdiction.